Hello friends, today our topic is res judicata and res sub judice, and now we discuss res sub judice. So we will highlight this. In section 10 it is required that previously instituted suit must be pending and is res judicata. In section 11 it is required that former suit must be heard and by the court. But in दोनों in two as to issue for the applicability of res sub judice, all the issues must be same in both suits. For the application of section 11, even 142 issues can be same in both suits. So now we will highlight this. Raising of matter under section 10 as a matter directly and substantially in issue in both suits must be raised by the parties. Under section 11 a matter may be become directly and substantially in issue even if it is not raised in the former suit on the ground of constructive res judicata. So now we will discuss former suit and we will show you the former suit is to be highlighted. Former suit under section 10. A former suit means a suit instituted prior in time. But now under section 11, a former suit means a suit which has been decided prior to the suit in question, where or not it was instituted prior in the time of 3-2. So now we will discuss the scope in both of them. Section 10 apply only suits, but section 11 apply both to suits and the issues, and now we will discuss on the same of them, so we highlight the issues. Section 11, but section 10 states the proceeding of the substantive suits. Section 11 bars the trial of a subsequent suit. Applicability. So now we highlight the applicability, and section 10 can be appealed and it can be staged after the framing issues and before the section of the suit. Section 11 appeal applies before framing issues and it must be raised in pleading. Now we will discuss defense. Defense of res judice cannot be taken in written statement. Defense of res judicata can be taken in written statement. So now we discuss kinds. Under section 10 there is no concept of the constitutive res judicata and the res judice. Under section 11 there is a concept of the constructive res judicata. As to criminal law, no parallel provision like res sub judicata is present in the criminal cases. Doctrine of dual jeopardy is present in criminal parallel to res judicata. So now we will discuss the conclusion and the main point of them. So to conclude that both doctrine of res judicata, res judice and res judicata basically aims at the welfare of society and police convince. Both doctrines are like in some respects, and where res judicata applies it states the proceeding of the subsequent suit till the first is disposed of and what is decided. It bars the jurisdiction of the subsequent suit by the virtual and the section 11. So now is the whole result. What will the kind of the result? So now discuss the scope, formal suits, effect, applicability, defense, kinds as a criminal law. So now as the whole result, we will discuss the provision and the section of the CRPC. So the cross reference of the CRPC. Relevant provision of following are the relevant provision regarding the topic of res judice and section 10 of the CPC. Cross reference. Section 151 of CPC, Article 203 of Constitution of Pakistan 1973. So now we discuss following are the relevant provision regarding the res judicata. And now we discuss section 11 of CPC. So we will highlight this. Cross reference. Section 151 of CPC. So now we discuss the CPC point of view. Crossing reference. Principle of res judice. Under Section 10 of CPC, the doctrine prohibits the trial of two parallel integration in respect of the same cause of action and the same object matter between the same parties. So our topic is finished, and thank you so much for watching.